I want to buy a bazooka, and I found a good deal on one in Europe. Can I buy it and own it and use it here in America?
Senator, I believe that falls under prohibitions in the National Firearms Act, but let me speak more generally, because I think that's right, but let me speak more generally to the Second Amendment question, which I believe is what you're getting at.
If you found a good deal on a bazooka in Europe, could you legally bring it back home? Welcome to American Hearings. Senator Kennedy just walked an ATF nominee through one of the more memorable Second Amendment hypotheticals in recent Senate history. But behind the humor is a genuinely important constitutional question about where the right to bear arms begins and where it ends. Let's break it down.
Since we have our ATF nominee in front of us today, I thought I'd ask you a little bit about our Second Amendment. I want to buy a bazooka, and I found a good deal on one in Europe. Can I buy it and own it and use it here in America?
Senator, I believe that falls under prohibitions in the National Firearms Act, but let me speak more generally, because I think that's right, but let me speak more generally to the Second Amendment question, which I believe is what you're getting at. There is a fundamental right enshrined in the Second Amendment to keep and bear arms.
Right.
And the Supreme Court has said in Heller, written by Justice Scalia, that is a personal right. It's not a right that is tied to being in a militia. It is a personal right that includes for defense. The Supreme Court has since elaborated on that doctrine, including in Bruen and most recently in Raheem. It is made clear that the test for Second Amendment rights is whether the right falls within the text, history, and tradition of this country. And so I would need to look specifically at whether a bazooka or a weapon analogous to it would fall under the protection of the Second Amendment using that test, if I were so lucky as to be confirmed.
Well, under Heller and Bruen, do I have unfettered discretion to own any kind of firearm that I want to?
There are certain exceptions that are listed within the decision in Heller. And for example, machine guns fall under the National Firearms Act. So there are certain exceptions to what arms can be owned. But again, I would go back to the text, history, and tradition test if a case were to come before me as a judge that was asking that question.
Okay. I'm sorry I didn't get to ask everybody questions. Thank you, Mr. Chairman.
Senator Whitehouse. Thank you, Chairman. Mr. Sakata, welcome. Thanks for coming to my office to talk about.
Welcome back to American Hearings. Leave it to Senator Kennedy to open a Second Amendment conversation by asking whether he can import a bazooka from Europe. It's funny. It's also deliberate. A disarming question is sometimes the sharpest way to start a serious one. The ATF nominee, to his credit, doesn't flinch. He pivots quickly from the bazooka specifically to the broader legal framework, and what he lays out is a clean, accurate summary of where Second Amendment law currently stands. Heller established the right as individual and personal, not tied to militia service. A landmark ruling. Bruen then set the test for evaluating any firearm regulation. Does the restriction fall within the text, history, and tradition of the right? And the more recent Raheem decision continued to develop that doctrine in important ways. So the question isn't just, is this a weapon? It's, does restricting this weapon fit within America's historical tradition? That is a significantly higher bar than most people realize. Kennedy follows with the unfettered discretion question. Do I effectively have the right to own anything I want? The nominee correctly identifies existing limits. Machine guns. Certain categories under the National Firearms Act. The right is personal, but it is not without boundaries. What makes this short exchange valuable isn't only the legal summary, it's what it reveals about the nominee's preparation. He didn't dodge the bazooka question. He used it as an opening to clearly explain a complex legal framework under pressure, in plain language, without stumbling. That's a skill worth recognizing. In the courtroom, in the hearing room, and in most high-stakes conversations. Subscribe to American Hearings for more Second Amendment coverage and constitutional breakdowns.